Okay, it is June 26, 2017. Eric Larson here with the Labor Commission, the Wage Claim Unit. I'll be hearing the case Mr. Rex Bagley versus Duke Services and Labor Finder Intermountain. Both claims are retaliation claims. Mr. Bagley's case against Duke Services is case number 17-01247. The case against Labor Finders Intermountain is 17-01245. And again, each of those cases are retaliation claims. Mr. Bagley made a motion at the start of this proceeding to have a different law judge hear the case. The responding parties did not oppose nor necessarily agree to that, but the commission decided to grant that, which is why I'm sitting in here in place of Mr. Rammel, Steve Rammel, the normal administrative law judge. Let's start, Mr. Duke. You're with. Tell me the company that you're representing today.
Duke Services.
Okay, thank you. That makes perfect sense. And Tammy and Courtney, you're with Labor Finders, correct?
Yeah.
Okay.
It's international, not Intermountain, so you know.
I'm sorry.
That's okay.
I was glancing at it upside down. Thank you.
Yeah.
All right. Thank you for that. For the record, it should be noted that the Labor Finders Intermountain Price Office has been removed as a party in this claim. I understand that our office served the Price Office previously, but that party will be removed from the order because they're not related in any way to the claims.
How are you guys listed in
Oh, was it?
the state database? I have a question before we begin. The scope of this hearing. Is the scope of this hearing just to determine whether there are the employers, or is this the actual hearing?
This is the actual hearing to issue an order on your retaliation claims against Duke Services and Labor Finders Intermountain.
Okay, because I was under the understanding, according to the notice, that this was just to determine whether they were They were the employer.
I'm not sure how you got that impression. It's the hearing for your retaliation claims against each entity, Labor Finders and Duke Services.
Well, I can go through the mail that they sent me and explain to you. Do we need to do that?
If you don't feel prepared to discuss or order or
It could be prejudicial, is what I'm saying. Ultimately, it could be prejudicial. I would move for summary judgment against Labor Finders and let this issue is precluded. The collateral estoppel would apply here because the issue has already been adjudicated or litigated in the Department of Workforce Services Unemployment Division.
okay, but you filed a retaliation claim in our office,
Yes, but the same facts.
which is separate from Department of Work Services.
But the same facts and assertions were already litigated in that case.
That's a separate case as far as this office is concerned.
Yes, but according to collateral estoppel.
No, I'm telling you, according to our processes.
Well, that would be my motion. Would you deny that motion?
Tell me your motion again.
That Labor Finders is collaterally estopped from relitigating the same facts and assertions that they litigated previously in the Department of Workforce Services Unemployment Division unemployment insurance claim.
All that I'm concerned with today are the allegations that you have made and the responses that the respondents have made in your retaliation claim that was filed in this office.
Which were the same assertions for the insurance claim.
And that decision was made in that office, and I'm here today to make an order on these claims that were filed in this office.
Correct, which is what I'm stating, this collaterally estopped. It says it's been previously litigated by another state agency, which would collaterally stop you from relitigating the same issues.
Then why was the claim filed in our office to begin with by you?
It hadn't been litigated yet.
It needs to be litigated now, which is the reason that we're all here today.
It has been litigated.
Not here, it has not.
No, in another entity.
That makes no difference to our processes here.
It does, according to collateral estoppel, so that's my motion.
I'm denying your motion.
Okay.
because we are here again to make an order on the retaliation claims that you filed.
Okay.